You may be forgiven for thinking that in Scots executory practice, the law is static. And I find in my practice that, in fact, the law is rather dynamic. And what I'm hoping to do in the next hour or so is to comment on a number of cases that have been decided principally over the last 12 months, extending maybe a few months before that, in which the law is developed. And I'm going to be talking about cases which affect executory and succession practice. I'm going to be looking at the facts of the cases. I'm going to discuss, where appropriate, the legal principles and relevant propositions. And I'm going to provide my commentary, and it really is my commentary, in relation to how the cases may affect executory and succession practice. Let me move on then to the next case which I'm going to talk about. And it's the case of Kay's executor nominate against Kay's former attorneys. This case concerned an action which was brought by beneficiaries. They were concerned about an agreement entered into following a deceased's death. And that agreement was a deed of variation. Now, the deed of variation itself was entered into following the death of one party, one spouse, but during the lifetime of the surviving spouse, who was an adult with incapacity. And the disappointed beneficiaries sought reduction on the basis that the attorneys had breached their fiduciary duty in entering into this deed of variation, the effect of which was to divert funds from that were destined for the estate of the survivor to charity. The pursuer's case was unsuccessful. And the difficulty in this case was that there was an estimated valuation. Now, the cases of Alexander against Alexander's trustees, and before that, an inner house decision in Gilchrist against Gilchrist trustees, were considered. And the proposition which is taken from those cases is that there is an estimated valuation unless estate is realised in ordinary course. And where estate is realised in ordinary course, and that normally means it reasonably in reasonable order, short order, not necessarily. But if they are realised in ordinary course and a different valuation is then, a different value is put to the item of estate, it is that different value which will represent actually the value of the estate. And the difficulty in this particular case was that there was no realisation.